We'll proceed initially in the matter of People versus Douglas Oliver Kelly, hearing first from Ms. Young.
Thank you, Your Honor. Evan Young, Office of the State Public Defender, appearing for Appellant Douglas Kelly. May it please the Court, in Edwards, this Court cautioned that allowing victim impact evidence under Factor A does not mean there are no limits on emotional evidence and argument. And in Prince, very recently, this Court, when describing a victim impact video that would violate due process, this Court described virtually word for word the video that was shown in this case. It was lengthy, it was set to very emotional music.
Just because it was lengthy, and well, I should reframe my question. When you criticize the video for being lengthy, are we looking at a particular time frame? In this case, it was 20 minutes. So from your standpoint, that was way too long. What would you permit in terms of a time frame, or are there other circumstances that you would want the court to consider in addition to a time frame?
Well, Your Honor, it's not just the time frame, not strictly the time frame, although one would have to say that 20 plus minutes is a very long time to be looking at these kinds of images. And I think it's the kinds of images as well that...
Why is that? Very frankly, I watched it, and I didn't think that what music there was of the type to evoke great emotions. It was just showing the victim at different points in her development, from being a small child to being a young woman at about the time that she was murdered. And maybe that's why it was long, because it showed her at different stages of her life. But very frankly, I think this Court's been confronted with victim impact evidence that has much greater potential to be prejudicial or to involve the jury in overly emotional reactions, perhaps, than this particular video. So I know you don't have much time, but I'd like you to say succinctly what it is about this particular bit of victim impact evidence, given the fact that we do allow it under U.S. Supreme Court decisional law, that makes it inappropriate.
Your Honor, this Court in Prince and in Robinson before that cited the case of Salazar in particular, which is a Texas case, which had the same music and also showed the victim from infancy to death. And that was part of the criticism by the Court in Salazar, in which I read this Court to adopt as something about which it was concerned in terms of victim impact. That
was the narrative of this video particularly emotional?
Not in and of itself, but
in fact, wasn't it really very matter-of-fact and calm?
Yes, it was, Your Honor. There's no question that it was. However, I think that the images, which were not only many, many still photographs, it also included some video footage in which the victim herself was speaking. But it was also, this videotape was also offered in addition to quite a bit of testimony by the victim's mother at the penalty phase.
Ms. Young, if we were to agree with you, basically the rule of law that we would have to make is to say that the trial court abused its discretion, because that is the standard. On what basis could we say that the trial court abused its discretion? You did mention that we described in Prince what wouldn't be a good idea, and that this videotape seems to resemble what we were saying wouldn't be a good idea in Prince. But how would you have us write, if we were to do that, saying that here, in what way did the trial court abuse its discretion, or is it just so subtle and dependent on the circumstances that it's whatever call we make?
Well, no, Your Honor.
Your time is up, but you may respond to Justice Werdegar's question.
Thank you. Your Honor, I think that in a case like this, a trial court should look at the entire volume of victim impact evidence that's being proffered by the prosecutor. And as I mentioned, there was extensive testimony by the victim's mother in this case, in addition to the victim impact statement, so that I think that there has to be some weighing simply in terms of sheer volume about victim impact evidence, which initially was admitted as I think the quote has been a brief glimpse of the victim's life, which surely the 20-minute videotape and extensive testimony exceeds.
All right. Thank you, Ms. Young. We'll hear now from Ms. Brennan.
Counsel, what is the purpose behind admitting victim impact evidence?
The purpose behind admitting victim impact evidence is to show, one, the impact of the loss of this person on her family. And secondly, it's also to show the uniqueness of the victim. And here, that's exactly what this videotape did.
Counsel, as a threshold issue, should the court to consider when deciding the nature and extent of victim impact evidence to allow, should the court consider the fact that a defendant puts on no defense and no evidence in mitigation, or is that a proper consideration?
It perhaps could be, but you must remember in this case, the determination to admit the videotape was made prior to the defense's determination as to whether or not they were going to put on any mitigation evidence. So maybe in other cases, but not here. And again, as this court has said in Edwards, that it's proper to put on emotional but relevant evidence for the jury to make the determination, the ultimate determination as to what sentence to impose. And here,
Counsel, this court's most expansive statement on videotape evidence that I'm aware of right now is the Prince case that opposing counsel referenced. May I just read a few things we said in Prince as to why the video in the Prince case was acceptable. The videotape interview with the victim did not constitute an emotional memorial tribute to the victim. There was no music, emotional or otherwise. The tape did not display the victim in her home or with her family, nor were there images of the victim as an infant or young child. The setting was a neutral television studio. As Ms. Young suggested, all those things were present in this videotape, however you might view it as appropriate or not. So what do we do with the language in Prince?
well, for one, the language in Prince would be dicta as to, because they found that it sort of wasn't this.
Carving out what it wasn't.
What it
Now
wasn't.
we have a case where it is.
Yes, and in this case, I think, again, what we must look at is to whether it was, whether the jury would see it as overly emotional and therefore cause it to base its decision on an irrational speculation, and that's what it was not. Here, it was, in light of Prince, in light of Robinson, yes, it was perhaps a closer case than prior to these, but it approaches, but does not cross that line.
What is the line?
The line is whether the trial court, when here, having viewed the videotape, decided that in light of everything, this paled in comparison. And the line is whether it would detract or take the jury away from its proper role of deciding the case on the facts. And here, this is what this videotape was showing, in the sense of it was showing who Sara was as a unique individual, which this court has allowed. It was showing the impact of her loss on her family, which is exactly what this videotape was showing. It was a brief glimpse to see what her personality was like. In the small parts of the video, we saw that she was a shy.
Why was that important in the context of this particular case?
It was important in the context of this particular case to see who she was. And
Isn't there something more than that? Are we talking about perhaps the particular vulnerability of this young woman? She may have been 19 years old, but presumably what one can glean from the record is that she had a lot of innocence.
yes,
And that's why I was framing the question to you in terms of vulnerability, and I would like your response to that.
yes, it was important to show the vulnerability of this victim. And it was important to show of who she was, of why appellant targeted her, and why he, in the past.
So why did he target her?
Because she was someone who would not put up an extended fight. Because she was so innocent. Because she was so trusting.
Did he lure her somewhere?
He lured her.
Did he use a pretext? And I would like to hear from you what?
Unfortunately, because he killed her, we don't have her testimony to say what he said to her. But what we do have is a circumstantial evidence showing that he did lure her to that apartment. And what we have is this. We have that she told her mother at 5:30 on Labor Day that she was going home, going to the room that she rented to do her laundry and get ready for work the next day. We have the telephone call that her friend made to her that evening. She couldn't find her. We have the telephone call that Sara makes the next morning at 9 a.m., where her co-worker says she sounded upset, and she said that Sara said that there was some suicide, that a friend had committed suicide, and there was no evidence of any sort of suicide. So, again, we have all of this circumstantial evidence of showing that, importantly also, that on Labor Day evening, it's Tony Mamon who drops off appellant at that apartment. And he tells him later on in a call that he is in that apartment. And the next day, or the 7th, I should say, that again, he calls Tony Mamon and says, I'm hanging out with this other girl, meaning someone other than his girlfriend there. So for all of those things, we know that she is circumstantially, and the jury could make this inference, that she was lured to that apartment. She was lured by appellant to that apartment so that he could rape her, rob her, and murder
Apart from the
her.
luring, getting back on the issue of vulnerability, naturally you would want this court to agree with you that there was nothing wrong with the videotape. And of course, we have heard the arguments from opposing counsel, who of course strongly disagrees with you, and we have to come up with a solution. Back to vulnerability. Well, you have taken the view that in this particular case, the 19-year-old victim was vulnerable. Now let's flip to the video, 20 minutes. What is there in the images that the adoptive mother of Sara showed that from your standpoint highlights the vulnerability of this particular murder victim?
I think some of the most important footage in that videotape is the video footage. For example, when she's at her mother's wedding and she doesn't want to be photographed. It shows her to be camera shy, sort of reticent and shy. Also, there's the approximately 3-minute portion where she's singing in the choir, having to do a solo, and her mom says it was so difficult for her to have to get up there and do this solo. You see her posture, the way she's standing, sort of like this. And it shows you sort of the type of person that Sara was, that she wasn't out there.
How old was she at that time?
At that time? Well, it looked like it was, some of it was junior high-esque looking.
Right, so, but at the time of her death, she was 19.
Yes. But I would submit to Your Honor that it seemed like that a person's shyness in public and her general personality, as it was sort of seen throughout the entire of this video, sort of showed her to be, again, that same vulnerable person.
Ms. Brennan, were we to agree with you? And we were to write, as we have to, a reason for why we affirm or reverse, how would you have us distinguish our language in print besides saying that was dictum?
Well, I think that the important thing here, too, is although there was music, it was music for a reason, not just for no reason. It was music selected because it was what Sara liked. It was what she was listening to at the time of her death.
What was the relevance to her life in the closing shot of the horseman riding off into the valley with music?
It was definitely unique to Sara because Sara was a Blackfoot Indian. This is where she was from. And as her mom said at the end, this is where she liked to imagine where she was. So it was unique to Sara and not just for no reason put in. And again, I think that we must remember that all of this, as Your Honor pointed out, is so tempered by the calm narration on this video. What you're left with is not an overly wrought or emotional video, but what you're left with is something that's calm and shows who Sara was and her loss to her
Opposing
family.
counsel argues that the combination between the mother's testimony and the video makes it repetitive. I think in her words, a massive amount of victim impact testimony. What is your response to that?
I would disagree, and I disagree for these reasons. As her mother testified, she said, I think of Sara at different ages, and this is what this video showed. And she said this is the way that she's able to, as the prosecutor argued to the trial court, how she was able to get across who Sara was to her. And again, I think it was only approximately 30 pages or so that the mother testified in victim impact, and there was this 20-minute video. And then we must also remember all of the evidence that came before that. There was approximately 80 pages of testimony from his fourth victim, probably maybe one of his first victims, of Esther D. And when we look at all of this, again, we must remember, was this going to take away from the jury in making its determination, making it based on emotion and speculation? No, because when we look at it, we remember that the trial court, at the time it's making this determination, has sat through the entire guilt phase, has sat through and watched as these three women, Kim, Jody, and Terry, got up there and testified about the brutal crimes he committed against her. Then he also sat through the afternoon testimony of Esther D. So when we look back, the effect or impact of this video just evaporates into insignificance when compared against the compelling testimony of all of his other victims.
Now, in Prince, did we simply find that there was no prejudicial error without making a determination whether there was error in the first instance of admitting the video?
No, I think Your Honors decided that there was no error in the first instance because it was such a calm interview. And again, that's the nature of this video too, its calm nature. Therefore, we would submit that there was no error. Certainly, the trial court did not abuse its discretion in making a determination that this videotape was admissible.
Well, when you strongly urge to this court that there was no error, I presume you probably also have a plan B, right?
Yes.
That even if this court were to have some problems with the video, in the final analysis, I'm making the argument for you, and I'd like to hear whether you agree or whether you want to refine that argument. And naturally, we'll hear on rebuttal from the opposing side. But let's assume that this court were to find some problems with the videotape. Is it your view that this court could certainly conclude that even if this court were to conclude that certain portions should not have been admitted at trial, yet in the final analysis, there simply is no prejudice that defendants suffered from the showing of the videotape to the jurors?
I doubt that wholeheartedly. Yes, it's true. This court doesn't even actually need to decide the issue as to whether it was admissible or not because of the overwhelming evidence in this case. And again, when you look at everything that was presented, all of those brutal rapes, this just wasn't any rapist or any robber. What he did to those women, he terrorized them. He brutalized them. He degraded them. This is what the jury was presented with. In the end, the jury voted for death, not because of who Sara was, but because of who he is. He's a brutal rapist murderer. He was a predator. Prior to killing Sara, he had a 10-year history of incredible violence against women. In the end, they found that all of the evidence presented, there was such overwhelming aggravating factors in this case that they voted for death. It could have been any woman. Here it was Sara, but they voted for death.
June 26, 1993. All of my children and nieces and nephews are in that picture. This is Sara with Jeffrey. And I As time goes by, I try very hard not to think of Sara in terms of this terrible crime that we've had to deal with here in the court, but rather think of her in a place like this, which is, this was filmed in southern Alberta, the land where Sara's people lived for so many generations. This is the kind of heaven she seems to belong in.